and welcome to the Corporate Counsel webinar. Today we're going to talk about data theft, trade secrets, and NDA tips to make your business info secure. And today we have Mr. Suaran Singh Sidhu. He's the head of dispute resolution technology, media, and telecommunications practice groups, and co-head of the IP practice group at Law Partnership. He is also the vice president of the Future in Tech community and was involved in drafting the Malaysian Forum Code. He is the committee member of Licensing Executive Society in Malaysia and a member of Malaysian IPA. Without further ado, Suaran Singh.
Hi, good morning, everyone. Sorry for the late beginning. We just had some sort of tech issues to resolve. Ironic that this is a tech talk in a way. Today I'll be talking about the importance of data and the things that can go right and also things that can go wrong. How do we deal with it? I didn't want to sort of just focus on the traditional, trade secrets and NDAs and the usual laws that go around it, but the issue of what has happened to data and technology, and in terms of also with the pandemic that's around us, the protection of data and information has become a far bigger issue for many. So I'm going to try to cover the whole idea of this talk is more introductory to let you know and be aware of the different kinds of information out there, different kinds of attacks that can happen, the different ways to protect it, and also some preventive measures. So it's not just going to be the traditional, how do you protect my trade secret? That's going to be the very conventional way of talking about information. But now I think it's more appropriate to spread out a little bit more and try to cover a broader spectrum of things. So we've got a lot to go through. So in the event, I'm passing by the slides too quickly, not to panic. These slides will be shared with everyone after the talk, so you will have a copy. So it's better for you to listen and engage with me. And do share your questions, which will be posted on the side. I may not be able to see them at the beginning, but I'll try to address them once the talk is over. Right? So let's start with So this is the kind of different type of the main content of the talk today. Looking at the types of different business documents, the storage, the theft, the trade secrets, and how does the law look at it, cyber attacks that have increased due to the pandemic, and the legal dangers that arise. Now, these are common business documents that most of you are aware of, and some of you may not realize that most, if not all of these documents are subject matter of different kinds of legal protection around it. Some by way of the trade secret protection, some by way of preventive, and some also in the context of the PDPA, the Personal Data Protection Regime in Malaysia. So all of this will come into one or two, or if not all the three categories. This, I'm sure all of you are aware how documents are stored, and the manner in which documents are stored also then results in how they are protected or how they can be breached. Again, some of these things are more sort of for you to take into account. I'm sure many of you are already aware of this. How do you, the importance of limiting control, encryption, those sort of things. I'll go into it a bit more later. Right? So everybody is aware most of the time that, if you have a data theft or a cyber attack, it does lead to a lot of consequences, which includes you losing the business, reputation comes into question, the authorities will start knocking on your door, right? And these things can happen in different angles. And I'll try to address all of them as much as I can this morning. So let's start with data theft, right? Now, data theft that has been going on, most of the time these days, we no longer look at situations where the data theft is in the physical data or paper that is stolen, but more has to do more with data that is stored in your digital servers, your soft copy, your digitized version of your data, and how these are taken from your IC identification information to important customer information and company information, right? So these are some examples of the data breaches that have been on the rise lately. Australia's Commonwealth Bank admits 2016 data breach. Back in 2016, millions of LinkedIn IDs were hacked. And then in last year, the Sephora Online in the Asia Pac region had a huge data breach. And these have only increased over time, right? The Credit Bureau in Korea also said that 40% of the population were affected. This was 5 years ago. And I'm sure it's just the level of assurance may not still be there because number of breaches around the world has increased. In Malaysia, recently also, there has been a huge dump, data breach dump of an online manner. Now, how does data breach occur? I mean, these are common ways in which it happens. Effective. I mean, all of us are probably aware that this needs to be, these things happen. But the fact is, how strongly are we looking into these kind of threats, these kind of issues? How many of us have changed our passwords in the last, 2 months? How many of us have looked into our networks to see have we put up sufficient firewalls? How many of us have looked into to see are there employees in the company who have left the company but they still have access to the cards and the passwords of the company, for example? Have we done all of that? And are we continuing to observe such things? So what I've just shared here are some of the tips in the office. I think most of the tech persons should be putting this in place. I think for the purposes of this talk, to ensure that we stay within the time, some of these tips, it'll be good for you to take back to your offices and get the tech persons to have a look at it. Some of these things are having to do with how often are you changing your passwords? Are you putting enough firewalls? This is a tech-related issue, but at least be aware of it. Have a checklist of things. I want to now go into the trade secret element, right? Now, trade secret, there are lots of cases in Malaysia that tells us what is a trade secret and how the courts have protected it. In the famous Schmidt scientific case back in 1997, which is still good law until today, the judge stated, and I read, trade secrets are not limited to manufacturing processes or trick or secret formulae, but extends to information relating to the list of names and addresses of the customers and suppliers, specific questions sent to customers, cost prices, specific needs and requirements of the customers, and status of ongoing negotiation with the customers. So it's not just about the manufacturing processes, which always people think, oh, it's a formula for Kentucky Fried Chicken, it's a formula for making a certain product. No, it's all your customer list, all your supplier list, and so on and so forth, things that you need to make your business to work. And in the same judge in the ElectroCAD case also then said, they looked at the definition of from the employee perspective and said information which any reasonable employee would recognize as secret to his employer's business, and then action for obligation, breach of confidence will lie where there is a breach of obligation for confidence. So it is not just from the point of view of an employer, all of you who are employers here, information that you consider to be important for the running of your business, but also from the employee's point of view, what should they ought to have known is secret, right? So these are main categories of confidential information: scientific data, technological and production information, private financial information, and business information. These are categories of things. Now, this can be used as a template for your clauses, for your NDAs and your employment contracts. You can use this to include that in your documents. So something practical you can take. So those of you who are drafting documents, you can take this definition and include it in the definition of what amounts to confidential information. I cannot stress enough on the insider threats. Majority of the cases that go to court eventually, when it comes to a breach of data, there's always some element of an insider breach. An employee who has gone to a new company, an employee who has been bribed, an employee who's frustrated with the boss, will end up taking a lot of information and then selling it to someone, or going to a competitor and trying to get a job at the competitor's office, will then use that data as leverage to get higher pay or to get employed. So things like leaving your mobile phone by your table unattended without passwords and going to the loo, for example, or leaving your computer screen unattended without any password locks and having a meal. These are the simple things that actually has resulted in breaches of data in a company. Simple things like that have caused it. Sharing your data across the employee platform, giving too much information to each other also has resulted in the same. So detecting that and putting in place mechanisms to ensure that that doesn't happen too easily is very critical. Outsider threats, of course, relies in the context of a third party, like a hacker of sorts, coming in and trying to hack into your business. And this is where you get those major data breaches that occur in the news headlines we mentioned earlier, right? So we can talk about the legal measures and the administrative measures you can put in place. So some of the things you can do is putting in place a very solid and strong non-disclosure agreement, strengthening your employee contracts, and also looking at your position under common law. We'll go into that in a bit. So non-disclosure agreements. In the recent case of Body Basics, 2018, the High Court has recognized in Malaysia that NDAs do play an important role in protecting information, right? So it is important to have NDAs in place. For example, if you have outsiders coming to your factory to have a visit, make them sign an NDA. It's very common these days. You're going to go into a negotiation with a potential supplier or distributor or retailer, have them sign an NDA to say whatever I share with you will remain secret, because your negotiations may not happen, may not result in a fruitful conclusion. But talks have happened, information has been shared. So it's common to have NDAs being signed. It's a very common practice now. It's not something that's frowned upon. So get a standard NDA done and just make sure that the two-pager thing is signed off by the other party, right? I also want to mention, for example, like in the case of motor data, this is the case that I did years back. The court explained that confidentiality agreements actually lays out the obligation of an employee, and it plays a very important role in enforcing the obligation on an employee. So employer-employee relationship, having a confidentiality clause in there does make a difference in the court. At least they look at it, and the courts do pay a lot of attention to those sorts of things, right? Now, what happens to someone who has left the employment? Now, I must tell you this whilst we're at this, yeah? The courts do treat obligation during employment and post-employment differently. For post-employment, the level of obligation that an ex-employee has reduces. So therefore, in those instances, only trade secrets tend to be the one that the courts will try to prevent disclosure. But during employment, the obligation is higher. So what's very important is that you have to identify in your contracts what is the confidential information, the type of confidential information you want to protect, and then ensuring that those are recognized as trade secrets, right? So the case of Svensson Hair Center, this involved an obligation post-employment. It had to do with breach of or the taking of customer list. So Svensson Hair Center, their business is trying to sell to customers, things that they can do with their hair and whatnot. So the list of the customers was critical. That's what the employee stole. And that was recognized as a trade secret of the company. Now, there have been instances, things that you can do when there's a breach. First thing, do you have an NDA in place? Do you have an employment contract in place? And the first thing you should do immediately, speed is of the essence, is go to court and get an injunction. And most of the time, if you have those documents in place, the courts are quite likely to grant you an injunction. That alone will prevent further leakage of the information. This is very important, right? So the last bullet point here is very critical for those who are listening in and figuring out how to protect confidential information. The confidentiality clause will fail to take effect if the employer is unable to prove and ensure that they have taken reasonable steps to protect the confidentiality of the trade secrets or confidential information. So the courts will look at the conduct of the employer. What exactly have you put in place? Have you put in place passwords? Have you taken steps to ensure things are done in a way where the employees are aware it's a secret? Have you put in place proper safety mechanisms? All those things play a role for the courts to see how seriously does the employer take that information, right? So these are the three things you need to show to satisfy an action in court. Very simple. One, is the information confidential? If the information is too general, you're not going to get the protection. Two, was there an obligation of confidentiality? Now, this is where contracts come in. Contracts will show that there's an obligation. And three, was there a threat or use of the information? Three basic things that the courts will look at, right? Now, there are instances also on the flip side. Now, this is where the employers should be a bit more mindful, okay? These cases went against the employer, which means it was in favor of the alleged thieving employee, right? Here, in the first case of Sigma, it said the court dismissed the plaintiff's case, employer, on the breach of confidence because the plaintiff failed to plead confidential information or trade secret. They failed to specify what is the secrecy, right? Because of that, the entire action failed. The case of Repco, again, same thing happened. The plaintiff cannot render a piece of information as trade secret by merely naming it as such. So if the information is general in nature, you cannot then try to cloak it by saying this is trade secret without explaining why it is trade secret and why is it important to you, right? So take note, if you're making it too general, it can backfire. So again, Sigma case underlines that the injunction was not available because it wasn't pled, the secrecy, what was the secret. Now, if there is no document in place, fear not, there's always that blanket of common law, which says that an employee does have an automatic duty of confidentiality. But those of you who think that this is enough, let me tell you, it is not. It is just a safety blanket. It is not going to give you the protection you need. Having contracts in place, clear wording, clear NDAs are always, always, always better than having nothing at all. Because even though the law has some kind of a safety blanket for you, a safety net, but that safety net is only going to be in the extreme circumstances. It's going to be harder for you to show the case. So just to give you an illustration, have your documents in place. Very important. Administrative measures, these are the things you can do. What are the steps you've taken? Implementing protocols and codes of conduct in place. Have a good manual. My advice to you would be have a decent handbook in the office where you have the strongest and the tightest wording on trade secrets and confidentiality, and let that be published internally in your office. So regardless of how the employment contracts are worded, the handbook will then guide and also inform everyone in the office, this is the standard that we expect of you. And that can be used in the court of law, right? Rather than having to amend every single employment contract, have a handbook in place and get everyone to do a sign off on that. That's pretty good. A shortcut. Some categories of protection plan to protect trade secrets, creating agreements, policies in place. Again, these are things you can do, practical things you can do, establishing a physical and electronic security and confidential measures, assessing risk, doing a due diligence. Yes, one good takeaway from this, I want to just sort of get to the gist of it, is have an audit. Conduct an audit, engage an external auditor, a law firm or a consultant. Let them come in and do an audit for you on your information on three aspects. One, is your documentation in place? That's going to be a legal audit. Are there sufficient confidentiality clauses? So that sort of thing, number one. Number two, do a technical audit. Are there passwords in place? Are there things at the doors that stop people from coming in? How is an ex-employee terminated? How do you take back information and ensure that there's no re-access into it, right? And thirdly, do a PDPA audit, personal data protection audit. How is customer information, client information protected, kept, stored, and maintained? And are the 7 principles being looked at? So do these 3 audits. It can be done by, the legal audit and the PDPA can be done by a consultant / law firm. Technical audit, you need to get a tech person to come in and have a look, right? So this will go a very long way in what you can do. And if there's a breach subsequently, you can show the court that you have done audit, you have put things in place, and that shows the seriousness of it. That's one takeaway that I would give all of you. Yeah, very simple and can be implemented immediately. So again, what I've just said to you are also measures that are recommended by WIPO. You can read that on your own time. Next, we move into cyber security attacks. Now, due to the pandemic, people are working from home more and more. The safety and the comfort levels that you get in the office network, the firewalls are all gone. You're not going to get firewalls happening in each person's home. Things are laid out. We do not know the condition of anyone's house, whether it's an enclosed environment. Are they sharing with someone else? Are there roommates in the house? How big is the space? Is anyone else tapping into the Wi-Fi and then entering your network? All these are real life threats that have happened and continue to happen. So these are some of the common scams that have happened. The most popular one is the phishing scam because everybody seems to fall for it. 90% of the cyber attacks begin with a simple phishing email. What is a phishing email? As the name says, it is a way to fish. It's like somebody sending a bait via email and hoping one of you will just take the hook, right? So it's an email that tells you, the World Health Organization has come up with a new guideline on the pandemic access. Or for example, for saying to you like, there has been a recent attack. Please click on this link and try to, change your password, right? Or for example, saying something like, there has been a further update on the customer information, and you click on it thinking that that's what it is. And before you know it, someone then sends a virus and plugs into your system, right? And these are emails that you think could be coming from a legitimate source, but in actual fact, they are not. From the phishing, the scams can start. From the phishing, the malwares can be installed in your systems, right? So how is phishing done here? The victims receive an email, seemingly from the government or WHO, for example. This is a COVID-19 situation. This happened. Redirection. Victims are then redirected to a website that looks like the official website of WHO. They're asked to download a file or some key information, and then the breach happens. The link or attachment downloaded may contain malware or a virus, and that this then leads to that attack happening in your particular system. It may not be immediate. It could take time, and I'll come to that in a bit. So for example, these are some of the emails, phishing domain names that were used to send out emails. cdc-coronavirus.com, cdc-coronavirus. So you had these kind of things going on, and you didn't realize because you heard of CDC, you heard of coronavirus, you're thinking, okay, this could be legitimate, but it's not. It's not a legitimate proper email, right? And then the email is compromised. That's one example. Another one that's quite popular, another form of phishing is business email compromise. So for example, it could be somebody in your organization whom you know, or an email that you're familiar, but it is like an imposter. It looks like it sounds like it, but it's not. So it could be, for example, let me give you a company like Nike. It could say general manager at nike.com. I mean, there may not be such an email, for instance. So the email appears as nike.com, but behind the scene, it's some other email, which you can't tell. So it's been spoofed. It's like, a wolf in a sheep's clothing kind of situation. That's what business email compromise generally is, if you think of it in that sense. So you go into it thinking, oh, my general manager is looking for me. You go into a panic. I got to answer this. Next thing you know, you've gone down the rabbit hole in getting into that scam more and more. It's just that first flip that happens in your mind, which you don't realize. And thereafter, as further down you go, you are down too late. You can't recognize it. So you must identify the email from the beginning, the get-go. Right? These are some examples that have instances of real life situations that happened in the last couple of months. Some Zoom accounts, there was all these Zoom bombing incidences you must have heard of. Compromised credential stuffing is like part 2 of phishing or a data breach. So for example, if somebody has found out the emails used, a legitimate email used in your company, there's been a data breach, right? Now from that data breach, you were wondering, how are people using that information? So my email is Sidhu@lawpartnership.com. Let's say that email has been breached. People out there have taken access to it and my password. And I'm thinking, all right, what are they doing with it? This is what they're doing with it. With my email, that email will then be used to send to other people who then think, oh, it's an email coming from Suaran. I'm sure it's legitimate. But unbeknownst to me, I have not sent any of those things out. So again, it's like a wolf in sheep's clothing. You have stuffed something fake by putting like a cover of authenticity of credentials on it. People may not realize it. These are being sold on the dark web. A lot of it, which may not even know. So all the data breaches you hear of in the news, do not think that that's the end of it. The culprit has been caught. No, that information data is floating around. It's not going anywhere. It's being sold, it's being traded. So if you think everything is all right, the authorities are on it, trust me, they are not. They are attacking. The authorities are going after the source in the sense that the company that failed to keep proper security mechanisms, they will never be able to find the actual culprit who could be hiding under layers and layers in the dark web. So your data is still there. I just want to cause a bit of panic here. Please go and change your passwords, all right? A cyber attack hits in the Asian hospital. There's one example in Singapore. I'll come to that in a minute, right? Why companies are most susceptible in teleworking environment? So as I mentioned, more people are working from home. Second box, organization data is going through less secure networks, and then there are points of breaches that arises through advanced persistent threat. Now, again, a fancy word, advanced persistent threat. What it basically means is that someone has taken tenancy and someone has illegally squatted or is squatting in your device or your computer without you knowing. So I remember I told you about the phishing situation. Someone has They'll send you a phishing email, you've clicked on it and nothing has happened. You have not seen that the whole screen going black or anything of that sort. You're thinking, all right, seemed okay, pretty innocent. But unknown to you, something has been planted in your device and is sitting there quietly. You will never know it. It's just sitting there waiting for the right time and gathering information, picking up information and sending it back somewhere. That is advanced persistent threat. It's a very innocent sounding name for a very sinister thing that is going on. It's just something that's dormant and waiting to launch, waiting for its next orders, so to speak. Right? Next, I move to the PDPA regime, the Personal Data Protection Act. It basically contains 7 principles that you need to look at. The one that I want to talk about would primarily be security, right? And also data integrity. So for instance, have you put in place systems and mechanisms to ensure that the data that you have with you, number one, is accurate? And if it's accurate, what is the level of access available to persons in your organization? And on top of that, what is the level of security that you put in place to ensure access is observed, monitored, and ensure there's no leakage? So I'll focus on the security principle. Again, what you see here looks rather dry and boring. Long story short, these standards and these sort of codes of practice, what they basically set out is to say what you need to do to ensure that the security of the data is maintained. So all organizations out there, especially organizations that hold a lot of customer information and employee information, if your organizations are huge, based on the participants that I see today, most of the organizations are huge. So you need to have a data protection officer in place. That DPO is not a fancy job, it's a painful job. The DPO has to ensure that all the security systems are in place, the tech is talking to them, there are safeguards, there are firewalls, and in terms of accessing that data, the DPO has to ensure who has access, how is it controlled. It's a lot of, the data protection regime is a thankless job in the sense that you only will know of its importance when something bad happens. So all the work that happens behind the scenes, nobody will know of it. But that work becomes critical when the authorities come knocking on your door, right? The company must guarantee that you provide sufficient security to protect individuals' personal data from hackers, as well as from your own employees. This can include technological security measures. Okay? This obligation also extends to third parties. Under the Data Protection Regulations of 2013, companies need to develop and implement a security policy for both their employees and third parties to follow. That means you're not only having to monitor your employees when it comes to access of the data, but also third parties to whom you give your data. Many of the processing that happens in big companies, the processing of the data is not really done in-house. It's actually done by third parties outside who specialize in analytics, specialize in algorithms, who look at personal data and try to make sense of it. They are given access to entire personal data of the company, but who's watching them, right? Who's watching the guards, so to speak? In a company be sued for a data breach. Under the PDPA, it doesn't bring about civil consequences, which means that you can't have member of the public suing under the PDPA. The member of the public can still sue under the contract because you would have a personal privacy policy. That would be a contract with them. They can sue based on those breaches, but that's separate. Under PDPA, it is a commissioner, a personal data commissioner, who has the right to initiate action, investigations, and prosecution. So the liability is not civil yet, it is criminal, right? If somebody has gained unauthorized access to your data, the commissioner can investigate and bring action. The penalty is a fine up to 300,000 or not exceeding 2 years of jail or both. Now, those of you who are listening, the second part is important. Directors, managers, or other similar officers have joint and several liability for non-compliance, which means if something goes wrong, it is not necessarily the DPO who's going to be in trouble. It is the director and the manager who can be liable together or individually or separately. So there is corporate liability on the company and the directors behind the company. It's a very serious obligation. One instance, there was a mention of data breach in Asia, medical data that is. So in Singapore, the DI equivalent or data protection commissioner fined two entities. One is IHIS, which is an organization in Singapore that processes medical data for the hospitals. They were fined $750,000, and Singh Health, which is your Singapore Health, the hospital itself, was fined $250,000. The level of data breach, I mean, Singapore has, what's the number of population in Singapore? 6 million now, I think, right? The number of data that was breached was 1.5 million. That's close to 25%, almost 30. So 1/3 of Singaporeans' medical data was breached and violated. That's a big number. So the fine was up to $1 million in combination for both. I don't think that was a criminal, like a jail term or anything, but this was pursuant to a cybersecurity attack because the commissioner found that the security that was put in place by IHIS was insufficient. Vicarious liability. Now, you'll be wondering, can an employer, and all of you are representing big companies, can your company, your employer, be liable for the acts of the employees, right? This is a very scary thing because if an employee were to take the entire data on a USB drive, which is what happened here, the employee took the information on a USB drive and just walked out and sold it, can the employer then be liable for that act? The court changed its position twice, yeah? So at the Court of Appeal, they said the employer is liable. Interesting thing is this, the act of the employee was a malicious act. The fraudulent act was a thievery of sorts, yeah? It was criminal. And in spite of that criminal act, the employer was found liable at the Court of Appeal level. But luckily for the employer, Morrison's supermarket, at the Supreme Court level in UK, the Supreme Court reversed the decision and basically said the acts here of the employee was malicious in nature and therefore the employer cannot be liable. Let me flip that around a little bit for you. If the act of the employee was negligence, for example, leaving the thumb drive on the table, or not being careful, or sharing the password with his or her spouse or other half, right? And that is not criminal, that's negligence. In that situation of negligence, right, Morrison's will be found liable for that negligence by virtue of the vicarious liability. Another important consideration in this case was the court also looked at the behavior of Morrison's, the employers. All of you representing the companies here, pay attention to this. How you behave after the data breach is just as important as how you would have behaved or ought to have behaved prior thereto. Because Morrison's conduct after the data breach occurred was looked at favorably by the court. They took serious measures, they gave all kinds of, they informed the public, they took steps to put in place further protection, they traced and gave all the help to the authorities. They did all that was done, that was necessary to minimize the leakage and the breach and the fallout. That was looked at favorably by the court and said, you have done what was needed, you are seen as a good data user, data controller. So that's important to know. So cover-ups are going to backfire on you. The more you try to do to protect it and inform the public and secure the data will be better, right? How do you protect yourself? Now we move on from PDPA, we move on to other kind of clauses you can have in your contract when dealing particularly with third parties. Disclaimer clauses, force majeure clauses, cyber insurance, and other things that you can do in the infrastructure. Disclaimer clauses work. Now, can you say in your contracts that anything and everything that happens, you're not going to be liable for it? That used to be the position in most circumstances, but it's a federal court case in Malaysia 2 years back, which has changed the law. So CIMB Bank against Anthony Burke. This case basically says you cannot exclude everything all the time in all circumstances. When it comes to doing your job, if your contract requires you to do ABC, you cannot exclude ABC. So for example, those companies I can see in the list, if your primary job and role is to provide secure networks, your job is to provide confidence in the data, by virtue of you doing that, you cannot then enter into contracts to other people and say, yeah, my job is to give you security, but if something were to go wrong, there's the hack in the systems and whatnot, I'm not going to like it. That is not going to be acceptable in court anymore. But there is drafting to which you can do to try to dilute the impact of this case. And we have done that with our clients. But it's still legal, but at the same time, it means try to hedge the risk to the point where it is acceptable. You can't say no entirely. You can't say disclaim everything altogether, but you can still try to play in a way where it does exclude to the extent where it's suitable to do so. Right? So be aware of this case, because due to this case, the entire exclusion clause was found to be invalid. Not just one part, the whole thing was struck out. Serious. Right? Force majeure clauses. Now, in most instances, if there's a cybersecurity attack, is your force majeure clause enough to help you? I would say no, because force majeure is basically French for a supreme event, a major event like an act of God. Usually means like, there's some kind of a bad weather, lightning, something that's happened outside your control. Cybersecurity attacks can be a force majeure event, provided you put it into your contract. Cybersecurity attacks that happen outside your control, despite putting in the best security measures, you want to say that in those instances, you shouldn't be found liable. Let me give you an instance. If you are keeping a lot of personal data and a data breach happens, if a customer were to sue you for that breach, can you rely on force majeure? I would argue, yes, you can, provided two things are satisfied. One, it is mentioned in the force majeure that you can do so. And secondly, you've done all you can to ensure safety of the information. So beyond that, you shouldn't be found liable. So do look back. This clause didn't used to be that popular, but due to the pandemic, people are including pandemics in the cyber as a force majeure event, cybersecurity attacks as a new force majeure event. And also, because I'm generous, I've drafted for you a force majeure clause that you can use in your contracts. So this is wide enough to cover epidemics, pandemics. I hope there will not be another one, and cybersecurity attacks. So you can use that and put it into your contracts. Right? Cyber insurance. I know I'm aware of the time. Just go a little bit quicker. So there are particular insurance. There are specific insurance you can take for cybersecurity attacks. So those of you who are dealing in technology, dealing with a lot of personal information, and there's a risk of potential attacks happening, you should take out, do not use an existing insurance and have an add-on cybersecurity clause. I would recommend you sign up to a standalone cyber insurance policy, right? And do look into it to ensure, does it cover all kinds of cybersecurity attacks or only targeted attacks? So look at the fine print, because the insurance companies make a distinction, whether it's a general cyber attack or whether it's a targeted cyber attack. It does make that distinction. So be wary of that. Again, what I just mentioned, but these are the things. So if you're looking at cyber insurance policy, this is the page you need to look at. Page 55 of the slides, just bear that in mind. What is the scope? Does it cover all losses? Next, will it cover also vicarious liability? If the insurance policies can cover it, but just make sure it does. Get the confirmation from your agent. And does it provide worldwide coverage? Because those of you who have establishments outside Malaysia, the attack could happen in, say, Singapore or the Philippines, and the virus then permeates into the Malaysian side. So you do want to look out into those kind of things. If your servers are separated, it can't cross over, you're all right. Retrospective claims. Generally speaking, in law, insurance policies do not cover retrospective claims, but there are exceptions for cyber insurance policies. Remember, I was talking about APT, the advanced persistent attacks, where things are just dormant. Now, some of you may not know or may not realize that some of these dormant little, monkeys or monsters are sitting in your devices. You may not know it. It might be there. So it is considered technically a retrospective event. It happened earlier. The so-called advanced persistent attack happened pursuant to a wrong phishing exercise gone wrong. So that those bugs or viruses, whatever they are, they could be sitting in your devices, say, a year ago, waiting for the right time. If you get the insurance policy, some may say the cause of the event happened a year ago, therefore it is retrospective, we don't cover it, something happens from that cause. So be careful about that. So you want to get an insurance policy that goes back and covers even dormant attacks arising from a dormant being that was there prior to the signing of the insurance policy. So look out for that. Yeah, these are the things that the insurance company will use to not pay out, right? So look out for that. You want to be ahead of the curve and try to look for these things, right? Criminal liability, too bad, is not going to be covered. So if the company acted in a criminal way, you won't be liable. You cannot claim the insurance policy for that. But if the employee does so, then it's a different story. So these are some tips for your tech person to look into, right? Encryption in place. I know some of these things can be expensive. I mean, do what you can, but things that you really can put in place, like tightening the contracts, training, doing a manual, providing sufficient guidance, getting an insurance. These are the things you can do. So I would say put the first line of your budget for those kind of things that can be implemented immediately. Overhauling your entire tech system is not going to be cheap, and it's a long-term thing. So maybe that can be phase 2 or 3, but things that you can already do in place right now, those you should start acting out anyway, and do an audit check. Those can be done immediately, right? Some of the things to look out for, as I was telling you, based on the Morrison's case, things you can do once a breach occurs, right? Take steps to isolate or cut off, stop the breach, blacklist the IP address. Number 3, assess the damage, collect information. 4, notify the stakeholders, make a report, right? NACCS is the National Cybersecurity Agency in Malaysia, right? That is the information that you might need, relevant information. And that's the end of the presentation. For now, I think I'm definitely on time. So I'm happy to take questions. Amira, are there questions?
So far, no. Does anybody have any questions? See one. Is it necessary for us to stamp the NDA?
Necessary for what, sorry?
For us to stamp the NDA, since we are going to have a lot of NDAs.
Oh, okay. So technically speaking, the law says all documents, okay, stamping does not, in lack of stamping, does not make the agreement less valid. That's the starting point. So if you don't stamp a document, it doesn't make the contract illegal or no longer recognized as a contract, right? The underlying contract remains. So stamping is on the document. Stamping is not on the relationship. So failure to stamp, what it means is that if you try to use the document in court, there could be objections. So stamping is a necessity for evidentiary purposes in court later, right? Of course, there are people who would say non-stamping it, you are depriving the government of revenue, is avoiding of tax, all that stuff. But putting that issue aside, not stamping a document doesn't make the agreement invalid. So being a lawyer, I would say you should stamp it. That's what the law requires you to do. But failure to do so, what happens is that if you want to use the document in court later, you then just pay the penalty at that point in time and get the document through. So again, it's your internal company policy how you want to do it. But my official stand is get it stamped.
Some more questions. There are some more questions. Hold on. Check. How do I access if my data is secure from theft, especially during working from home? And how do I keep my company data safe?
How do I access if my data is secure from theft, especially during working from home? I mean, if your data is safe, your data is safe. What I would say is your tech person just has to ensure that the proper systems are put in place. This is more of a technical question, really. So what kind of systems have you put in place to ensure no one is able to breach into your systems? How big is your organization? How often are people changing their passwords, right? How do I keep my complete data safe? I mean, there are many ways to keep it safe, though, right? Things like, are your information served? Is the information on a cloud? If it's on a cloud, who has access to it? Do you restrict access? If someone is leaving the organization, how do you then ensure that the person doesn't walk away by downloading the whole data, for instance? Do you then, do you take physical steps of removing the ability to copy by USB drive or something or the other? So these are the things you look, so basically asking yourself, asking us, putting yourself in a position that, look, if I'm an employee and I want to be naughty, I want to take all this information out, how can I do it? And then take steps to stop that.
Is there any more questions? How can we discharge parties from the liability of cyber attacks from third party in the NDA?
All right. So if I understand the question correctly, you're basically asking me, how do you, what can you do in the contracts to ensure that you're not going to be found liable? I think that's how I read it. So, Puan Noor, Mazita, let me know if I'm not really...
Is that correct? Just let us know.
Yeah, I hope my understanding is correct. Basically, what can you do with the documents? What can you do? What kind of contract clauses can you put in place so that your liability, if a cyber attack happens, is reduced, right? That's how I understand the question. First of all, have a force majeure event in there. Force majeure clause to be tightened up, so you reduce the level of liability. Secondly, having an insurance reduces your liability in the sense that you are, if someone were to come after you, you have a blanket, a safety blanket beneath you to at least ensure that you're not having to pay the whole sum, for example. Thirdly, a good exclusion clause or disclaimer clause can help you, because you can then separate your liability where you think it's fair to put the risk on you versus cybersecurity, which despite your best efforts, you will not have known. For instance, if you're a telco company or a data company or data hosting company, your entire role, one of the roles, would be to ensure that your hosts, your streams of cables are secure from third-party attacks, right? So if you put in place enough security measures, enough backups, enough like firewalls and antivirus and whatnot, if you've done all that, now in spite of all that, cyber attack still happens, unavoidable, right? Now, that customer or whatnot was going to come after you and say you failed in your job. In that situation, you want to then go back and say, it's a force majeure event. It happened. It was not within my control. I tried my best. It is something outside my control. Therefore, force majeure event, I'm not liable. That is round one. If that fails, then you can say, my liability is limited to amount XYZ because I've done what I had to do. My job, I was supposed to provide you services ABC. Attack that happened falls outside ABC. Because it falls outside ABC, I cannot be found liable, right? That's step number two. If that also fails, then you rely on your insurance to say, all right, they're coming after me. I'm not able to, my two sort of protections have both fallen. I now need the insurance company to step in and pay for the losses that I'm going to suffer because of this third-party suit. So that would be how I would look at it.
Is there any more other questions? If there is no more questions, I would like to thank Mr. Suaran Singh for speaking. Thank you so much, and thank you everyone for attending this webinar. Have a good day. All right.
Bye.
Thank you. Bye.